Hello there guys, as I've promised, today we're going to talk about the breach of a contract and the civil procedures for the award of damages to the party that has suffered. So let's begin with the breach of the contract. A contract has various terms that can be breached. These terms can be classified as the warranty, the condition, and the innominate term. If there is a breach of the condition, of the term condition, it is a big, one can say, breach of the contract that's gonna affect the heart of the contract and will give the right to the innocent party to terminate the contract and demand the reward of damages. If there is a breach of the term warranty of the contract, it is a minor violation of the contract and will not give the right to the innocent party to demand a termination of the contract, but will give them the authority, the right to demand the reward of damages. If there is a violation of the innominate term of a contract, it can be either treated as a violation of the warranty or the condition, depending on the circumstances. So I believe you understood basically what are the various terms of the contract that can be breached. And now let's go on to distinguish between the actual breach and the anticipatory breach. An actual breach is when I fail to perform my contract decently, or I do not even perform the contract. I discard the performance of the contract. Anticipatory breach of the contract is when I state clearly that I will not perform the contract. So that is the difference between the two terms. And now I believe that it is time for us to go into the civil court procedures for the award of damages. Let's say that I am the innocent party in the agreement, and I decide that I'm gonna proceed with file a claim form, file a case against the one that has breached the contract. What is the entire procedure? What is the first where is the first hearing going to take place? The first hearing is going to take place at a county court, and in some cases it's going to take place at a high court. If there's an appeal, a first appeal will take place at the Court of Appeal, the civil division of the Court of Appeal, and the final appeal will take place at the House of Lords in extreme cases. But what is exactly the procedure? What does the claimant needs to do in order to initiate a case? Well, he needs to complete a claim form, and then this claim form needs to be sent to the defendant. The defendant will receive the claim form and the response pack. The response pack will include, amongst others, an acknowledgement of service form, a defense form, and an admissions form. The defendant will have 14 days in order to file a defense form. If he fails to do that, then the court may rule without him, and a default judgment may be asked and demanded by the claimant, and the claimant may even win the case. The claimant will receive, if the defendant files a defense form, the defense form, and he will talk with his lawyer and arrange all the necessary actions. Both of them, the defendant and the claimant, will receive final questionnaires, where the goal of these questionnaires will be to arrange the time and the location and the track of the trial. What do I mean by track? There are three specific tracks of allocation. We have the small claims track for cases up to £5,000. We've got the fast track for cases up to 5 with £15,000 of damages, and we have the multi-track, which is for the reward of damages for £15,000 and above, which are more complex cases. So basically, this is it about the procedure of the civil courts for the breach of a contract, and if the case, if the court decides that there needs to be an award of damages, the court will take into consideration the loss of bargaining by the defendant, by the claimant. What did the claimant lose from this breach of contract? Let's say that the defendant sold to the claimant a television, and the television was broken, or he didn't even deliver the television. Then the claimant will claim let's say if the television was worth of £400, he will claim the £400, and also if the selling price of the television, the market price is £500, he will claim an additional £100. Also, the court will take into consideration the consequences on the claimant of the breach of contract, and by weighing all the things, the court will decide what damages need to be awarded to the claimant. You must take into consideration that the court, in order to award damages, the damages need to be not to be too remote, and there needs to be a link, a causation between the breach of contract and the damage caused to the claimant. So guys, this is it generally about the civil court procedures and the award of damages in contract law. Thank you so much for staying tuned. Stay tuned for the next episode where we're going to talk about criminal law. It's going to be so exciting. Thank you so much.